Hi, I'm Rav Pratap, and this is a tax lawyer's perspective on the GST Council. In this video, I examine the role and functions of the GST Council as envisaged in the Constitution. I eschew from a qualitative analysis of the GST Council's work and instead focus on the constitutional provisions that enable its creation and functioning. I refer to one case, the Mohit Minerals case decided by the Supreme Court in 2022, but I discuss only those parts of the judgment that are relevant to the GST Council. The caveat for this video is that it is not an exhaustive view on the GST Council. The aim here is only to provide an overview of its role in the GST ecosystem. I examine the relevance of GST Council on these 5 touchstones: its role in the GST ecosystem, its composition, manner of arriving at decisions, method of resolving disputes that may arise from its decisions, and finally, the section to which I devote maximum time, the legal value of recommendations of the GST Council. Let us begin then. But before I delve into all these 5 aspects, a brief background as to why the GST Council was created. Before GST was introduced, India was not one indirect tax jurisdiction, but an assemblage of multiple indirect tax regimes, with the Union levying its own indirect taxes and each state adopting its own indirect tax policy. Union, for example, levied service tax, interstate sales tax, excise duty, and customs duty. Each state levied and collected its own sales tax, which later on became value-added tax, entertainment tax, excise duties on alcohol, and octroi, as well as entry taxes. Both the Union and states determined their indirect tax policies independently and without any major coordination with each other. In the year 2000, an empowered committee of state finance ministers was constituted to facilitate and coordinate the transition of states from sales tax to value-added tax. Later on, the representatives of union territories were also included in this empowered committee. This empowered committee was also responsible for laying the initial groundwork of GST when it released the first discussion paper on GST in the year 2009. As the idea of GST, a nationwide consumption tax, took hold, it became clear that to facilitate and implement a nationwide consumption tax, both the Union and states had to pool their sovereignty and agree to simultaneously levy GST. But if both the Union and states were to simultaneously levy GST, how would they coordinate their decision making? Thus, in addition to numerous other questions that had to be addressed about GST's design, there was also a need to determine the kind of forum that would enable the Union and states to jointly make decisions on GST. One thing was evident: this joint decision-making forum needed to be permanent in nature and not an ad hoc or a stopgap arrangement. So while the empowered committee of state finance ministers existed, it wasn't considered to be adequate. A more permanent forum was needed given the importance of GST and the massive change in indirect tax regime that accompanied its implementation. In other words, a forum for exercising and displaying cooperative federalism, a term coined by the Supreme Court. The 13th Finance Commission, in its report released in 2009, underlined the importance of creating a body like GST Council. The Commission observed that since GST will be the first time both the Union and states simultaneously levy the same tax, it was important that a decision-making body on GST is rooted in the Constitution. The Commission recommended transforming the empowered committee into a council of ministers and provide it with the necessary legal backing. Overall then, the creation for GST Council can be traced to the need for a more permanent body with clear decision-making criteria, pre-decided protocols that includes representatives of the Union, all states and Union territories, a forum for discussion on GST where the role of each constituent entity, states and the Union, is clearly delineated and which facilitates collective decisions on GST. So while the need was clear, designing this forum was not a straightforward exercise. With this background, let me examine the GST Council in reference to the first touchstone, its role in GST policy making, and in the process, cast a slightly narrow lens on the GST Council. In short, the role of GST Council is to give recommendations on GST policies. And the various aspects of GST on which the GST Council can provide recommendations are enlisted in Article 279A of the Constitution. I will quickly read through the various parameters enlisted in Article 279A. Article 279A Clause 4 states that the GST Council shall make recommendations to the Union and the states on the taxes, cesses and surcharges levied by the Union, the states and the local bodies which may be subsumed in GST, the goods and services that may be subjected to or exempted from GST, any model GST laws, principles of levy, apportionment of GST that's levied on supplies in the course of interstate trade or commerce under Article 269A, and the principles that govern the place of supply. The threshold limit of turnover below which goods and services may be exempted from GST, the rates including floor rates with bands of GST, any special rate or rates for a specified period to raise additional resources during any natural calamity or disaster, and special provisions for certain states such as Arunachal Pradesh, Assam, Jammu and Kashmir, Manipur, Meghalaya, and so on and so forth. Now clearly, under Article 279A, the GST Council is entrusted with a role that involves providing recommendations on a wide array of GST related issues. And these issues involve crucial provisions of GST laws, including but not limited to tax rates, who is exempt or not exempt from GST, and creating special provisions and exceptions for a select few states. Apart from the issues enlisted expressly, Article 279A4 subclause H also states that the GST Council can provide recommendations on any other matter relating to the GST as the Council may decide. Now this is a wide clause, as the use of the phrase any other matter not only empowers the Council to decide as to what would be the any other matter, but also includes within scope a wide array of issues that are not expressly listed in Article 279A. And of equal importance, the recommendations of the GST Council can span both the legislative side and the executive side. In the sense, the GST Council can recommend either enacting a new law or amending an existing law. And GST Council can also recommend issuance of new notifications, circulars, and any other similar secondary legislation. Overall, you can see that GST Council is envisaged as this apex policy-making body for GST, and its remit practically covers the entire expanse of GST. To summarize then, GST Council is envisaged as a body or a permanent forum for the Union and states to collectively take decisions on GST. It is the de facto successor of the Empowered Committee of State Finance Ministers, but the Council has a more specific and earmarked mandate. The GST Council is also envisaged as a body that provides guidance and recommendations in relation to GST, and its recommendations typically precede any legislative changes or executive decisions which are taken both at the union and the state level with respect to GST. Now let's move to the second touchstone. What is the composition of the GST Council? This part is relatively straightforward. Article 279A Clause 2 states, the GST Council shall consist of the following members, namely, the Union Finance Minister shall be the chairperson, the Union Minister of State in charge of Revenue or Finance shall be the member, and the Minister in charge of Finance or Taxation or any other minister nominated by each state government shall be the members of the GST Council. Thus, the Union and State Finance Ministers technically constitute the GST Council, with the Union Finance Minister being the ex officio chairperson of the GST Council. Just a few words on the composition of the GST Council. So while the GST Council issues recommendations that are de facto expert recommendations on GST, its composition of political representatives makes it unique. Another constitutional body that deals with revenue distribution and provides expert recommendations is the Finance Commission of India. But the Finance Commission of India is exclusively comprised of experts and technocrats. The GST Council acquires a different color because of its composition. And I'm saying this only to suggest that the GST Council is envisaged as a policy-making body of political representatives, specifically political representatives that deal with finance at the union and state level, and can meet and discuss GST issues at this forum, provide recommendations before the legislature or the executive takes a final call on the recommendations. Which leads me to the third touchstone. How do these political representatives take decisions in the GST Council, since there are bound to be disagreements on some issues between the union and the states? Article 279A, Clause 9 states that every decision of the GST Council shall be taken at a meeting by a majority of not less than 3/4 of the weighted votes of the members present and voting, and this shall be in accordance with the following principles. Where the vote of the central government shall have a weightage of 1/3 of the total votes cast, and the votes of all the state governments shall have a weightage of 2/3 of the total votes cast in that meeting. In percentage terms, this means that 75% is the minimum votes that are needed to pass a decision in the GST Council. All states together have approximately 66% votes, and the central government of the union has about 33% of the total votes cast. Which leads me to the question, what is the implication of this distribution of weightage in votes? The implication is that all states together cannot pass a decision in the GST Council. The union by itself cannot pass a decision in the GST Council. It needs at least some states on its side. But in my opinion, overall the union seems to have an edge, as for any decision to go through, it has to say yes. All states together cannot take a decision in the GST Council and bind the union with it. The union necessarily has to agree in the decision for that decision to pass in the GST Council. The union defended the above weightage of votes by arguing that neither the union nor the states will be able to take decisions on their own, and both would enjoy a veto. The union reasoned that the union will require the support of around 20 states or union territories to get a resolution passed, and since it will necessarily require the support of states to get a resolution passed in the GST Council, it means that both the union and the states basically are dependent on each other in the GST Council. So while these facts are true, it conveniently sidesteps the fact that a resolution in the GST Council cannot be passed unless the union agrees to it. In my opinion, the union has a permanent veto in the GST Council. Though another way of looking at this is that the union having to necessarily agree arguably ensures that there is some sort of uniformity in GST that will be preserved. But I will leave you with this one question. If all states collectively agree on a decision, why not allow that decision to pass in the GST Council? Because that will also ensure uniformity across all states, only that union will have to concede to the collective decision making of all states. Maybe something for you to mull over. To summarize this part on decision making in the GST Council, despite the union's advantage in voting weightage, the primary purpose of establishing the GST Council is to act as a federal body that allows collective decision making by both the union and states and displays cooperative federalism in action. And this spirit of collegiality seems to have largely played out, as the union and states have rarely resorted to voting in the GST Council. Out of the 56 odd GST Council meetings until now, most decisions have been taken by consensus, and voting has only taken place on rare occasions in the GST Council. Alright, now that I've elaborated on the first three aspects of GST Council, let me move to the fourth aspect: resolution of disputes relating to decisions and recommendations of the GST Council. But I will discuss this aspect of disputes in two subparts. Let me begin by the first subpart, or Chapter 1. GST-related constitutional amendments were finalized via the Constitution 101st Amendment Act of 2016. But the first attempt at these amendments was made by the Constitution Amendment Bill of 2011. The Constitution Amendment Bill of 2011 originally proposed Article 279A, Clause 8 to state that every decision of the GST Council taken at a meeting shall be taken with the consensus of all the members present at the meeting. Decision via voting was not envisaged in the original version of Article 279A proposed in the Constitution Amendment Bill of 2011. Equally, this Amendment Bill of 2011 proposed Article 279B, Clause 1 stated that Parliament may by law provide for establishment of a GST Dispute Settlement Authority to adjudicate any dispute or complaint referred to it by a state government or Government of India, arising out of deviation from any of the recommendations of the GST Council that results in loss of revenue or affects the harmonized structure of GST. The other clauses of Article 279B provided additional prescriptions in the composition, powers, and jurisdiction of the GST Dispute Settlement Authority, a body that was supposed to be a standalone dispute resolution body, envisaged to resolve disputes if a state or a union took decisions that did not align with the recommendations of the GST Council. But there were some concerns about the GST Dispute Settlement Authority. And these concerns were stated in the 73rd report on the Constitution Amendment Bill of 2011 by the Standing Committee on Finance. The committee in this report observed that the GST Council will perform a useful role in making recommendations, but the ultimate authority as to whether to accept such recommendations lies with the Parliament and state legislatures. In this respect, states had expressed concerns about setting up of the GST Dispute Settlement Authority. Under Article 278B, GST Dispute Settlement Authority was given the power to adjudicate disputes arising out of deviations from the recommendations of the GST Council. States expressed concern that the GST Settlement Authority can strike down their laws on the ground that they deviate from GST Council's recommendations, even if the law is otherwise constitutional. But since the Constitution Amendment Bill of 2011 itself was shelved, this concern of states was not addressed immediately. This brings me to the second subpart, or Chapter 2, about dispute resolution vis-à-vis GST Council. Let's fast forward to 2014. Well, a lot of things happened in 2014. I will only talk about the Constitution and GST. Now, partly because of the concern expressed by states about the remit of the GST Dispute Settlement Authority, the Constitution Amendment Bill of 2014 changed how the disputes will be adjudicated. Article 279A, Clause 11 stated that the GST Council shall establish a mechanism to adjudicate any dispute arising out of the recommendations of the Council or implementation thereof. And the dispute can be between the Government of India and one or more states, or between the Government of India and any state or states on one side and one or more states on the other side, or between two or more states. Now, three major changes that I wish to highlight between the Constitution Amendment Bill of 2011 and the Constitution Amendment Bill of 2014. First, in 2014, it was decided that there will be no permanent GST Dispute Settlement Authority. Second, If any dispute arises, then the GST Council was given the power to establish a mechanism to adjudicate any dispute. And third, the adjudication mechanism was now allowed to adjudicate on any dispute arising out of the recommendations of the GST Council. While previously the GST Dispute Settlement Authority had power to only adjudicate on disputes arising from deviations of recommendations of the GST Council. So the changes in the 2014 Constitution Amendment Bill were made due to concerns about the previous iteration about dispute settlement. The main concern being that of the states that a permanent dispute settlement authority, such as the GST Dispute Settlement Authority, proposed in 2011 was likely to impinge on the legislative powers of the Parliament as well as the state legislatures. While in the second iteration in 2014, the GST Council itself was given the powers to establish a mechanism to adjudicate on any disputes that may arise from its recommendations. The second iteration, proposed in 2014, eventually found its way in the Constitution. But even this manner of dispute resolution comes with its own set of challenges and/or shortcomings. What are the challenges? Let me point out a few obvious ones. The GST Council now has the powers to establish a mechanism to adjudicate disputes arising from its own recommendations. This creates a perception of bias. If few states disagree with, or let us say they don't implement recommendations of the GST Council, or there is divergence in interpretation of recommendations, then the Council itself will establish a mechanism to adjudicate disputes from its own recommendations. And since it is the GST Council whose recommendations will be in dispute, and is the same body that has the power to establish a dispute resolution mechanism, bias and lack of fairness are an obvious concern. But it seems the Union and states were apparently of the view that the current mechanism is better than creating a permanent GST dispute settlement authority. So let me summarize this part. The Constitution Amendment Bill of 2014 had removed the provision on GST dispute settlement authority. The Rajya Sabha committee, which examined this bill, actually recommended that the provision concerning the dispute settlement authority be reintroduced. But the Union defended the exclusion of the GST dispute settlement authority by arguing that the GST Council will only be deciding on the modalities of dispute resolution and will not be adjudicating disputes itself. This justification, to my mind, seems weak, as the concern about the current manner of dispute settlement is not about actual bias, but the perception of bias. Equally, concerns expressed by states about GST dispute settlement authority were valid and could not have been dismissed easily. It, in my view, boiled down to choosing one subpar option as opposed to another, or you could say one imperfect option as opposed to another imperfect option. GST Dispute Settlement Authority raised issues about impinging on powers of state legislatures and the Parliament, while empowering the GST Council to set up a dispute resolution body creates a perception of bias. Though it must be said that until now there has been no occasion to invoke this provision, and these concerns will only manifest if and when there is a dispute arising out of GST Council's recommendations. And this brings me to the final parameter, recommendations of the GST Council. To recall, the GST Council, once it takes a decision, issues recommendations to the Union and states. GST Council is a constitutional body consisting of political representatives. So from a tax lawyer's, or you could say a constitutional lawyer's perspective, the question is whether its recommendations will be binding on the Union and states. Or can the Union and states disregard the GST Council's recommendations? The question on legal value of GST Council's recommendations were addressed by the Supreme Court in its judgment of 2022 Union of India versus Messrs. Mohit Minerals Limited. This is the summary of Mohit Minerals' judgment insofar its observations on the GST Council are concerned. In this case, the Supreme Court had to engage with multiple issues and questions. One issue that the Supreme Court had to engage with was, what is the legal value of GST Council's recommendations? The union and the respondent, Mohit Minerals Limited, highlighted different aspects of the GST architecture and the role of GST Council to make their case. The Supreme Court referred to the legislative history of GST in significant detail and concluded that the recommendations of the GST Council were not binding. It created one exception and said that the GST Council's recommendations relating to notification of GST rates are binding. Having told you the summary, let me elaborate on the case a little bit. To begin with, what were the union's arguments? The Union of India argued that the GST Council's recommendations should be considered binding because, firstly, the entire GST structure will collapse as each state will be free to levy its own tax collection mechanism. The union's fear was that the pre-GST indirect tax regime will re-emerge with each state devising its own GST policy. Secondly, the union argued that if the GST Council's recommendations are not binding, then there will be no dispute to be resolved under Article 279A Clause 11, as states will be free to disregard the recommendations of the GST Council. Mohit Minerals, on the other hand, argued that the GST Council's recommendations should not be considered binding because, firstly, it will violate the supremacy of Parliament and state legislatures since both have a simultaneous power to levy GST. Mohit Minerals said that Article 246A of the Constitution, which was inserted in the Constitution by the Amendment Act of 2016, provided that both the Union and states have power to make laws in relation to GST, and neither of them supersedes the other. Secondly, Mohit Minerals argued that accepting the fact that GST Council's recommendations are binding will violate the fiscal federal structure, since the voting mechanism of the GST Council is such that no resolution can be passed without the union's consent. And since the union enjoys a de facto veto in the GST Council, making recommendations of the GST Council binding will create a federal hierarchy in favor of the union, which is not something that's envisaged in Article 246A of the Constitution. The Supreme Court agreed with the arguments made by Mohit Minerals. Supreme Court relied on the concept of cooperative federalism to emphasize that the GST Council is a body where the union and states cooperate to take decisions. And Supreme Court based its conclusion about legal value of the Council's recommendations on two major pillars. First, the absence of repugnancy provision in Article 246A, and second, the union possessing 1/3 voting share in the GST Council as provided in Article 279A. Let me elaborate on the Supreme Court's observations a little bit. To begin with, what is a repugnancy clause? A repugnancy clause is contained in Article 254 of the Constitution, and it basically gives primacy to the union law if a state also enacts a law on the same subject matter and the state law is inconsistent with the union's law. And this is likely only going to happen if the subject matter in question is in the concurrent list or list 3 of the 7th schedule. But Article 246A operates independent of the repugnancy clause. Article 246A, Clause 1, which gives legislative powers in relation to GST to both the union and states, states the following. Notwithstanding anything contained in Articles 246 and 254, Parliament and subject to Clause 2, the legislature of every state have powers to make laws with respect to goods and services tax imposed by the union or such state. Now you see here, Article 246A says notwithstanding anything contained in Article 254 which contains the repugnancy clause. So that clearly tells you that when the Union and states enact GST laws in exercise of powers under Article 246A, then the repugnancy clause cannot be applied to these legislative powers in relation to GST. Article 246A ensures thus that the legislative powers of both the Union and states are simultaneous or coextensive. And Supreme Court distinguished simultaneous legislative powers from concurring powers and added that only the latter are subject to repugnancy, not the former, implying that both the Union and state GST laws stand on equal footing. However, the Supreme Court added, under Article 279A, the weightage of votes in the GST Council gives primacy to the Union, since the Union's vote carries 1/3 weightage, and no resolution can be passed without the Union's consent. So while the Union also cannot pass the resolution on its own, the weightage of votes is in favor of the Union. So what is this Article 246A and Article 279A, Tango? 246A provides equal legislative powers to the Union and states because the repugnancy provision doesn't apply to it. While 279A, which provides for the constitution and voting of the GST Council, gives voting weightage to the Union or a de facto veto to the Union. But since 246A does not operate subject to Article 279A, the Supreme Court said making recommendations of the GST Council binding under the latter provision will create a hierarchy in favor of the Union, and that is not the intent of Article 246A. Reading 246A with 279A, the Supreme Court concluded that the GST Council's recommendations cannot be binding. The Supreme Court was also motivated by the larger idea of cooperative federalism, a term I've already stated twice or thrice in this video, and the Supreme Court's conception of GST Council as a site where cooperative federalism is displayed. Hence, Supreme Court refused to accept the argument that if recommendations of the GST Council are not considered binding, the GST structure will crumble. The court said that such an argument diminishes the role of the GST Council as a constitutional body formed to arrive at decisions by collaboration and contestation of ideas. The GST Council, the Supreme Court hoped, would not be a body where there are disputes and contests and where there is instead collegial decision making. Now, you can say that the Supreme Court's conception of GST Council as a body where there's collegial decision making is slightly ideal and utopian, but I don't think there's much fault to be found in Supreme Court's reading of Article 246A and Article 279A of the Constitution. And in Supreme Court's own words, the conclusion, Articles 246A and 279A were introduced with the objective of enhancing cooperative federalism and harmony between the states and the centre. However, the centre has a 1/3 vote share in the GST Council. This, coupled with the absence of the repugnancy provision in Article 246A, indicates that recommendations of the GST Council cannot be binding. Such an interpretation would be contrary to the objective of introducing the GST. However, the Supreme Court also created an exception to its above conclusion. Supreme Court commented on the nature of GST Council's recommendations and noted that under Article 279A, the GST Council's recommendations are non-qualified. That is, there is no explanation in Article 279A as to whether these recommendations are binding or persuasive in nature. Also, the recommendations do not of themselves transform into legislation. A further legislative action is needed by the respective state legislatures or the parliament, and the recommendations are not required to be tabled before the parliament. Only secondary legislation, which is framed on the GST Council's recommendations, is required to be tabled before both houses of the parliament. On observing the journal nature of the GST Council's recommendations, the Supreme Court then addressed some provisions where rulemaking power of the government could only be exercised on recommendations of the GST Council. For example, Section 5, Subsection 3 of the IGST Act states that the government may, on the recommendations of the GST Council, by notification specify categories of supply of goods or services or both, the tax on which shall be paid on reverse charge basis by the recipient. How should such provisions be interpreted? Would they imply that GST Council's recommendations are by default binding on the government, that is, both the union and states? Because such provisions enjoin the union to act on recommendations of the GST Council, the court said that these provisions should be interpreted purposefully. The aim of GST is to implement a uniform indirect tax system and to prevent states and the union from prescribing different tax slabs and different rates on goods and services. Adopting this purposive interpretive approach, the Supreme Court observed that the recommendations of the GST Council are made binding on the government when it exercises its power to notify secondary legislation to give effect to the uniform taxation system. Then the court went on and added that merely because few provisions of the primary legislation such as IGST Act and CGST Act, which are enacted by virtue of the powers given in Article 246 of the Constitution, make some recommendations of the GST Council binding, does not mean that the Constitution provision makes all their recommendations binding. Constitution provisions cannot be interpreted based on primary legislation, it is the other way around. The court then reiterated that Article 246A, read with Article 279A, makes the GST Council's recommendations non-binding, but the fact that certain statutory provisions make some of the recommendation binding does not alter the scope and meaning of the constitutional provisions as such. Another way to understand this observation is that the GST Council's recommendations are not binding on the Union and states under Article 246A or 279A of the Constitution. But if in exercise of these constitutional powers, some statutory provisions have been enacted which make these recommendations binding, then it cannot alter the meaning and interpretation of the constitutional provisions itself. It only means that the Parliament and state have chosen by enacting certain statutory provisions to be bound by the GST Council on some matters, which in this case is matters relating to notification of tax rates. But otherwise, under the Constitution, the GST Council's recommendations are not binding on the Union and the states, and certainly not on the Parliament and the state legislatures. To sum up then, what is the profile of the GST Council? The GST Council acts as an expert body that provides valuable recommendations on crucial dimensions or aspects of GST. It also acts as a forum of political contestation as relevant political actors of the Union and states deliberate, discuss and arrive at decisions relating to GST. As I said earlier, most of the decisions in this GST Council have been taken by consensus, and only on rare occasions voting has decided the issues. Though the voting weightage ensures that all states collectively cannot pass a decision, the Union must necessarily agree for the GST Council to validly pass a decision. And the dispute settlement mechanism that is finally incorporated in Article 279A is, in my opinion, a subpar mechanism that was chosen in favor of an earlier subpar mechanism that envisaged creating a permanent GST dispute settlement authority. Then, moving on to the recommendations of the GST Council, these recommendations have until now proven to be the most contested issue. In fact, very narrowly put, the legal value of these recommendations has proved to be the most contested issue. The Supreme Court's observations in Mohit Mineral's case that the GST Council's recommendations are not binding on the Union and states created a lot of concern about the future and integrity of GST. The majority of the concerns were centered on the fact that states may ignore the GST Council's recommendation and create their own GST systems in the form of different tax slabs and different tax rates. However, in my opinion, most of these concerns ignored Article 246A, which provides equal or simultaneous legislative power to the Union and states in relation to GST. This, in my view, means that states can enact their own GST laws that are at variance with the Union's GST laws. The fact that the states have not done so means that they really don't have the incentive to do it, at least not yet, or at least not until now. That doesn't mean they do not possess that power under Article 246A of the Constitution. I'm not done yet, just one more thing. By way of an addendum, this is a brief comment on the organogram of the GST Council. So when you look at the organogram of the GST Council on the GST Council's website, you find the list of bureaucrats who've been posted there. But I have a slightly different sort of perspective on this. As I mentioned earlier, the GST Council consists of political representatives, but they in themselves are insufficient to address the complexities and challenges posed by GST and thus arrive at informed decisions relating to various aspects of GST. The GST Council thus is aided by committees such as the Law Committee or the Fitment Committee or the GST Implementation Committee, and these committees almost by default consist of bureaucrats that do the background work and research on various issues relating to GST, and then these issues are brought during the GST Council's meetings and then they are discussed in the GST Council's meetings. Analogous to this, the GST Council often sort of creates certain group of ministers which consist of certain select members of GST Council, and they are often constituted to examine an issue that might be posing a challenge or that might require a bit more detail. And these group of ministers then examine this issue threadbare before the GST Council discusses the issue in a meeting. Both these, the committees and the group of ministers, are in my opinion crucial but ignored bodies that aid the working and functioning of the GST Council and contribute to the decision making in the GST Council and help it operate in a smooth and relatively successful manner. Now I'm done. Thank you for sticking around till the end. See you next time.